A little bit of breaking news for you here. If you are born in the United States, you are an American. That is not breaking news. That is something that is written in our Constitution and has been true for the duration of our republic. That said, when Donald Trump was sworn in for his second term 30 days ago, he signed an executive order that proclaimed that to no longer be true. This, of course, was immediately challenged in court. And among the federal courts it was laughed out of was one in Washington State, a Seattle-based federal judge ruled that Trump's executive order could not go into effect. The judge passed an injunction against the executive order going into effect. The Justice Department, the Trump administration then appealed that. They've appealed it to the Ninth Circuit U.S. Court of Appeals, which sits on the West Coast. And tonight, a three-judge panel of the Ninth Circuit has just declined the Justice Department's request to get rid of that judge's injunction to let Trump's executive order go into effect. The reason this is important is because this sets up potentially a rocket ship, very quick trip to the United States Supreme Court. When Trump passed this executive order, he knew, he had to know, that it was blatantly unconstitutional. The point of passing it anyway, of signing it anyway, was to get the Supreme Court to rule to effectively change the Constitution, to make it so that if you're born in this country, you are no longer a citizen. With this ruling tonight from a three-judge panel in the Ninth Circuit, this would appeal to be teed up for a challenge directly to the U.S. Supreme Court. One of the first matters that Trump has provoked a conflict with U.S. law and constitutional understanding about that is going to the Supreme Court. This ruling just in moments ago from the Ninth Circuit. We'll keep you posted as we learn more. Now it's time for the last word with the great Lawrence. Oh, Donald.
Rachel, so this was one of those nights when I'm walking through the hallways to get here, and the silent TV monitors that I'm walking by show you with some pretty important breaking news about birthright citizenship, and I can't hear a word of it. All I know is there's this thing at the bottom of the screen that says, this really important thing has happened. I've taken a quick look at the breaking news report on it, and it's a Trump-appointed judge is saying, no, this case can be handled through the standard procedures and it's not an emergency. We don't have to go into an emergency mode to deal with your attempt to hand rewrite the Constitution.
Yeah, and it's very well written. It's written in non-legalese. Yeah. Judges are charged to reach their decisions apart from ideology or political preference. When we decide issues of significant public importance and political controversy, hours after we finish reading the final brief, we should not be surprised if the public questions whether we are politicians in disguise. In recent times, nearly all judges and lawyers have attended seminar after seminar discussing ways to increase public trust in the legal system. Moving beyond wringing our hands and wishing things were different, one concrete thing we can do is to decline to decide or pre-decide cases on an emergency basis when there is no emergency warranting a deviation from our normal deliberate practice.
Just tonight, the appeals court, the Ninth Circuit, said they're going to keep the block on Trump's challenge to birthright citizenship. It's going to remain on hold, and it's going to go to a hearing.
Big surprise that the Ninth Circuit ruled against the president.
Okay, the Ninth Circuit is made up, just so you know.
Well, as shocking as the judge is.
So it's going to the Supreme Court. Hello.
Hang on, Robert. The Ninth Circuit is made up of a Trump appointee, a Jimmy Carter appointee, and a George W. Bush appointee.
Okay.
So, just so people understand.
It's something in the water, though.
It is yet another example. The courts are stepping in.
Well, to a certain, so listen, I was a chief executive. I was the mayor of New Orleans for 8 years. And I remember saying, I'm the head of this branch of government. I want to do X. And a lot of times the city attorney came in and said, Mr. Mayor, I represent the city. I'm not your personal lawyer. This is what the law says. This is what the Supreme Court says. And as a lawyer, as an officer of the court, there's certain arguments that you can make within bounds. But if you go and misstate the law to an appellate court, to a Supreme Court, you have an obligation to say that's really just outside of the bounds of what we are.
And isn't that just common sense, Brian? Shouldn't it be the case that the law says what it says, and that faithful public servants should go to their bosses and say, Mr. President, I know you want to do this, but here's what the law says. And that happened in the first Trump administration. Why are they suggesting that in order to do that would be some form of insubordination
Because
this
the final rule in this is not the law, actually. It's the Constitution. The Constitution, plays a guiding light in this, and the Congress makes up laws, and the Supreme Court decides, whether those laws are within bounds of the Constitution.
And you got a lot of lower court judges saying, well, it's absolutely clear that the 14th Amendment authorizes birthright citizenship. I'm not so sure about that. And the Supreme Court's going to be the final word. Yeah. And even if you disagree with me about that,
I actually agree with you, Robert,
we have to travel down this road first.
Yeah, but to your question as what happened and Trump won, there was a lot of cabinet secretaries, starting with Jeff Sessions, who ended up getting fired immediately by Trump when they told him no. And so this time he has managed to surround himself with people who will not tell him no.
Just to get us back to where we started, okay, what you said I think is absolutely correct. This is going to go through the court system. But what Trump and his staff secretary, and apparently Emile Beauvais, he said this to one of the prosecutors who refused to drop the case against Eric Adams here in New York City. Your oath to uphold the Constitution does not permit you to substitute your policy judgment for that of the president or senior leadership of the Justice Department. I mean, either the law is the law or it's just subject to whatever the president thinks at any given day.
Abby, President Trump got elected. He got a mandate. He won all swing states. He feels that all these agencies should follow the will of where his law he wants the state to go.
What role does the law play in all of that?
He's testing it. He's going to test it every single day.
I guess that is fundamentally going to be the question of the next 4 years.
And if you disagree,
that is fundamentally going to be the question of the next 4 years is whether or not
and you think your oath requires it,
Robert,
you resign.
There's a question here about whether or not there is a role for the law when a president politically, for political reasons, decides he wants to do something.
Can I ask, Robert, does it bother you at all as an officer of the court, which I am as well, that the prosecutors in the Southern District of New York, who were Republicans and conservatives and highly regarded lawyers,
and
that worked for Supreme Court justices,
and in D.C.,
their consciences was so bothered by this that they said, as lawyers, we don't think that we can do that. That should give lawyers pause for a minute. It's not that the president doesn't have the power.
Apparently, there are 900 former federal prosecutors.
Does not have the power to fire the mayor. Just have a hearing about the possibility of removing the mayor. And in that hearing, if the governor decided to have one, she would not be able to use any of the criminal evidence collected by the FBI and presented to a federal grand jury, which led to the criminal indictment of Mayor Eric Adams on bribery and other charges. So there would be zero criminal evidence available to the governor to consider in such a hearing. Zero. And so the magic bullet firing scenario that you've been hearing from people who literally in every real sense don't know what they're talking about is impossible. Also, at exactly 2:31 p.m. today, the Trump White House issued their proclamation from their king about congestion pricing. Exactly 2:31 p.m. And at that very minute, Mayor Eric Adams was testifying under oath for the very first time in the criminal case of United States of America versus Eric Adams. Federal Judge Dale Ho, who has been presiding over the case of the United States of America versus Eric Adams, was hearing a motion by Donald Trump's Justice Department to just dismiss the charges against Mayor Adams, a motion that was opposed by all of the New York City federal prosecutors who were handling the case. In all, 8 federal prosecutors in New York City and Washington have resigned over what they believe is an illegal scheme to dismiss the case for political purposes. One of the briefs filed in the case today included a letter from Danielle Sassoon, who was the acting U.S. attorney for the Southern District of New York, her 8-page letter offering her resignation and her refusal to file the motion to dismiss, accused acting Deputy Attorney General Emile Beauvais of entering a quid pro quo for the dismissal. The letter said, Mr. Beauvais proposes dismissing the charges against Adams in return for his assistance in enforcing the federal immigration laws. The reasons advanced by Mr. Beauvais for dismissing the indictment are not ones I can, in good faith, defend as in the public interest and as consistent with the principles of impartiality and fairness that guide my decision making. Danielle Sassoon's letter also reveals that she and her team of prosecutors were ready to bring an additional indictment against Mayor Adams, saying, "We have proposed a superseding indictment that would add an obstruction conspiracy count based on evidence that Adams destroyed and instructed others to destroy evidence and provide false information to the FBI, and that would add further factual allegations regarding his participation in a fraudulent straw donor scheme." Émile Beauvais could not find any attorney in the Justice Department willing to stand in front of the judge today and argue in support of that motion. We saw the unique spectacle of an acting deputy attorney general appearing as a litigator in court, which they virtually never do. One of the prosecutors who quit rather than stand up and tell the judge what he believes to be lies in the courtroom today, said in his resignation letter last week that he was confident that Émile Beauvais would be able to find, quote, enough of a fool to do it. Émile Beauvais did it. Émile Beauvais told the judge, "I'm here personally to answer your honor's questions, to give you the assurance you need to sign this." Judge Ho began the hearing by asking Eric Adams, under oath, if he was on drugs. That is actually a standard question for defendants in hearings like this, to establish that they actually comprehend the proceedings that they are in. The judge clarified that the Trump Justice Department intends to hold out the possibility of bringing these exact charges against Eric Adams